Hello everyone, a very good afternoon to all of you. Today we have with us Advocate Harshit Batra sir, who will be giving a seminar on the RERA, which is very important and crucial topic, I must say. And today we have with us CA Kashinath Pathare sir, who is a Vice Chairperson of Pune branch of ICAI. I would like to request Kashinath sir to please please give the welcome speech. Over to you, Kashinath sir.
Thanks, Sukanya. Good afternoon, all of you. Warm welcome on behalf of Pune branch for this webinar on RERA. Today we have very interesting topic, updates in RERA. Thanks, Harshit Batra sir, for confirming and giving first confirmation for this webinar. Also, thanks all participants for overwhelming response for this webinar. Thank you. Wish you happy learning. Over to you, Sukanya.
Thank you, Kashinath sir. Thank you. Now I would like to introduce our today's speaker, Harshit Batra sir, who is an advocate. So let me brief about him. He has completed his LLM in alternate dispute resolutions from Guru Gobind Singh Indraprastha University, Delhi. He has done post-graduation diploma in corporate laws and management and also in international and national IPR, one from corporate laws and management from Indian Law Institute and Institute Delhi, and post-graduation diploma in international and national IPR from Indian Academy of International Law and Diplomacy. He has also completed LLB. He has done diploma in cyber laws from Government Law College, Mumbai. He has also done certificate course on consumer protection and on IPR as well. He has been guest speaker at various webinars and conferences, including ICAI, ICSI. He has also done publications, paper titled Hybrid Dispute Resolution Mechanism, Scope and Adaptness in Different Jurisdictions of the World, published in the Indian Council of Arbitration, Quarterly, Volume 205, April to June 2020. Article on the law on RERA from the perspective of an allottee, published on livelaw.in. Article on financial bearing on the promoter's separate bank account, RERA, published on Tax Guru. Article on RERA, a bird's eye view, published on CA Club India. Paper titled Women in Business World, Remedy in Law, published by Springer Publication and further accepted to be published as chapter 4 of the book titled Women in Entrepreneurship in India. Articles on RERA, Protection to Builders, published in realtyplusmag.com, and a UP RERA judgment where he argued that the builders aren't always in the wrong, has been published in the print version of Amar Ujala in Noida region on 13th August 2021, which is a recent one. And there are so many publications. His work experience, I'll tell you. He has expertise in the RERA litigation, compliances, and advisory work. Along with that, he has work experience in criminal litigation, dispute resolution, retainer with Imar India Limited, and scope of work includes drafting of complaints and replies against or for the allottees, appearance in Haryana RERA matters. He has been empaneled with GLD Infra Project Private Limited, and the scope of work includes drafting of the replies to the allottees and appearance in the UP RERA matters. He has also assisting Honorable Dr. Justice A.K. Sikri, former Judge, Supreme Court of India, International Arbitrator, and presently Judge, Singapore International Commercial Court, in the preparation of various arbitration awards, legal opinions, and research work. He has been a national coordinator of Youth Bar Association India. He has been online faculty at Law CPE for the Executive Certificate course in Real Estate Law. He has been a former legal executive at Haryana Real Estate Regulatory Authority in Gurugram. Extracurricular, part of the grand jury.
Thank you so much, Sukanya ji. I think that we need not read the whole profile. I think we should begin with the webinar.
I must say, sir, it's fabulous profile, I must say. And at your young age, sir, I must say that. Definitely. I would like you to please go ahead with the session, and we cannot wait to hear from you, sir.
Thank you so much, Sukanya. Have we got expected audiences to begin?
So audience is already joining because we are participants. So they will be already, they must have joined already. Reshma madam, can you just tell me how many participants have joined?
Sorry, ma'am.
किती participants आपले join झालेत म्हणजे attendees?
Around 500 आहेत आता.
आता 500 आहेत. Okay.
Oh.
Okay.
Right. So let's begin with the session now. So I'll be sharing my PPT, which is though being recorded. Apart from this, you will also have my mobile number and email ID. If there are any queries, of course, you can put in the chat box, or after the session, the questions be put to me. If I'll be unable to cater to any questions, then you can resort to dropping a text on my mobile or sending an email for that matter. So let's talk about builder-buyer disputes. So builder-buyer disputes prior to RERA, what were the remedies? And after RERA, what is the difference? So prior to RERA, there were civil courts who were entertaining these builder-buyer disputes. But now when RERA came, Section 79 of RERA explicitly has put a bar that anybody cannot be going to a civil court and RERA simultaneously, which is reiterated in a very recent landmark judgment, Imperia Structures Limited, which is a 2020 judgment. Apart from this, there is a lot of confusion to people that after RERA, can we resort to criminal jurisdiction, to NCLT, and to consumer forums, etc. Now, the Apex Court has made it very clear that we can resort to consumer forums also. It is up to us whether we want to go to a consumer forum or to RERA. We can also go to both consumer forum and RERA if the cause of action and the relief that we seek are different and are not identical. As we all know, that RERA has come up with a special legislative effect that is catering the real estate market. There are many sections which are talking about explicit provisions relating to the real estate industry, which were not present in the Consumer Protection Act. Now, in Consumer Protection Act and RERA, there is a difference between the definition of allottee and the definition of a consumer. A consumer is somebody who buys anything for his own self-use, end use. Then only he can be termed as a consumer. And in allottee, he can be a consumer, he can be an investor, he could be anybody, falls within the ambit of allottee, and so he can approach RERA. Civil courts, as soon as RERA comes, civil court, it's a cross. You cannot go to civil court. If somebody is going to civil court, the judges are writing in orders that the legislature has passed the special statute, RERA. You need to resort to RERA and you please go to the appropriate forum. Then consumer matters, of course, the remedies are available. And after the amendment, the jurisdiction is as follows, that matters up to rupees 20 lakhs will go to the district consumer redressal forums. Matters between 20 lakhs to 1 crore will go to the state consumer dispute redressal forums, and matters exceeding 1 crore will go to National Consumer Dispute Redressal Commission. Now, Section 71(1) of the RERA Act provides a choice to the complainant to withdraw its complaint pending before the consumer forum or the commission and file the same before the for adjudication before RERA. So this makes it clear that there cannot be double jeopardy, there cannot be two litigations going on in two forums, otherwise that shall be termed as forum shopping. Whereas if your line of action is different, you're seeking different reliefs, then you can do the same. Then we talk about NCLT. The position is very clear. I'm sure that all the CS here would be well versed with this Pioneer Urban judgment, in which it was held that home buyers are considered as financial creditors as per Section 7. And then they've put limits of at least 100 home buyers or 10% of the total home buyers to go in NCLT. Then arbitration, the scope was made clear in the Nilkamal judgment, also followed with Pioneer. Now, how is Maharashtra RERA tackling with this situation where if the developer or the allottee says that I want to resort to arbitration? This is a judgment of Maharashtra RERA that I put in forward here, which says that arbitration arises from agreement between the parties in a real estate dispute can enter into an arbitration or, in fact, in other forms of dispute resolution. However, the mere presence of the arbitration clause in the builder buyer's agreement will not stop the parties from taking alternate remedies. So it is the choice if you want to go to arbitration or to RERA. But it is always said that a special legislation will prevail over a general legislation. And RERA is termed as a special legislation over the Arbitration Act. And because RERA has come up with a summary proceeding, okay, arbitration is also for an year and 6 months extension and everything. But still, RERA, if you see what the statute reads as, it talks about the matters being disposed of in 2 months, 60 days. So accordingly, it is said that it is a special statute and you can resort to RERA. Now, there are many people who want to go in criminal jurisdiction. They want to invoke criminal jurisdiction in such builder-buyer disputes. Now, what is the pattern that I'm seeing pan-India for this? That it is not easy after RERA coming into picture for you to get a FIR filed for cheating under Section 420. And if you approach the court for filing a FIR under 156(3), that FIR be filed, then the court will not file FIR for one person that all the ingredients of Section 420, that is cheating, are being satisfied. They'll see if the public good has been hampered. So in the cases where courts have ordered FIR to be filed are those wherein the public good has been hampered. So it's not like if one person is going, of course, the economic offences wing, they have their own jurisdiction that up to these rupees, if a fraud has been committed, that you can come up. But otherwise, if you're going through a court channel, they see if public at large has been affected. If given the option of all these forums, why should one be opting for RERA? Number one, as I said, adjudication under RERA is to be done within 60 days. Second, RERA is in special enactment to preserve the rights and interests of home buyers and have a fixed penalty in case there is a breach of any of such rights by the promoters. As RERA deals exclusively with real estate matters, whereas other forums have all kinds of disputes relating to interest of consumers, so there are more chances of getting a relief faster than any other forum. Then the proceedings before RERA appellate tribunals are deemed to be judicial proceedings and so have the same importance as the civil courts within very less time. Who are the stakeholders in RERA? It is the allottee, the promoter, and the real estate agent. Now, here I'll tell you what my opinion is. I feel that there should be another stakeholder, which is the bank or the NBFCs for that matter, even if we limit their scope to the tripartite agreements that they enter into, or the scope as relations with builders and for a particular project that they would have approved and for the loan purposes of a particular unit, but they should be included. Because when we seek relief from them, if it was a scheme wherein some pre-MIs were to be paid by the builder, tomorrow they stop paying. We want to make bank a party. Nowhere in the act bank is defined or bank has been made a stakeholder. Whereas I feel that because in these relationships that are formulated in the real estate market, bank is one of the stakeholders against which we need to seek relief. Sometimes banks also need to seek relief. So in place of going to SARFAESI, they can also approach RERA for a faster and better relief in terms of a tripartite agreement or any other thing. But apart from that, as I said, that in this, unlike Consumer Protection Act, the definition is of an allottee, which is very wide, that takes into consideration that allottee in relation to a real estate project means the person to whom a plot, apartment, or building, as the case may be, has been allotted or sold or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer, or otherwise, but does not include a person to whom such plot, apartment, or building, as the case may be, is given on rent. So it makes it clear that it does not cater to the rent relationships. Apart from that, any sort of a transfer, you are in allottee and you can go to the RERA. Now, a very recent judgment of February 2021 of Maharashtra RERA, Navnath Associates versus Mr. Anand Tambe. In this case, the court has defined an allotee, taking it forward from the act, it says an allotee is one who enters into an agreement with the builder and whose rights from the act. Only a person who enters into such an agreement has the right to file a complaint. As I said that can an investor be an allotee? Unlike consumer forums, RERA does not differentiate between a consumer and an investor. Now there was a question which was arising that are subsequent purchasers who has been nominated by the first allotee and has been transferred the unit considered as an allotee for the purposes of RERA, and will he be having the same rights and obligations as the first allotee? Again, a very recent judgment and a very landmark judgment has come up from the Supreme Court, Lauret Bidwell versus Saranjit Singh. In this, it was held that it cannot be said that a subsequent purchaser who steps into the shoes of an original allotee of a housing project in which the builder has not honored its commitment to deliver the flat within a stipulated time cannot expect any even reasonable time for the performance of the builder's obligation. Such a conclusion would be arbitrary, given that there may be a large number, possibly thousands of flat buyers waiting for their promised flats or residences. They surely would be entitled to all reliefs under the Act. In such case, a purchaser who no doubt enters the picture later surely belongs to the same class. Further, the purchaser agrees to buy the flat with the reasonable expectation the delivery of possession would be in accordance with the bounds of the delayed timeline that he has knowledge of at the time of purchase of the flat. Now, Lauret has cleared a position that, for instance, if a booking was made in, say, 2010, further a transfer was made to a subsequent allotee, say, in 2015, and the project is still ongoing. So when the transfer happens, somebody who's coming into the shoes of a allotee in 2015, where the project is already delayed, has the knowledge of the delay. This is one thing which is important to understand here, that he has the knowledge of delay already, and still he's entering into the shoes of the previous allotee. But what are the rights of this allotee coming into picture in 2015? He has the same rights of the previous allotee. When? How can we differentiate this? So if there has been an endorsement from the previous allotee to this allotee, or if there has been a transfer from the previous allotee to this allotee, then the rights and obligations will remain the same because this allotee has paid the previous allotee. But what happens if there is an addendum to the agreement that they would have entered into with the previous allotee? If a fresh builder buyer agreement or a fresh flat buyer agreement has been entered into between the builder and the subsequent allotee, then the rights might change. Then he might still have rights to seek release from the builder, but they may not start from the beginning, and it will not be termed that he's come in the shoes of the previous allotee. He will have the rights of allotee, but not probably the rights of the previous allotee. Now, when we talk about promoter is a person who constructs or causes to be constructed an independent building or a building consisting of apartments or converts an existing building or a part thereof into apartments for the purpose of selling all or some of the apartments to other persons, including his assignees. A person who develops land into a project, whether or not the person also constructs structures or on any of the plots for the purposes of selling to other persons, all or some of the plots in the said project, whether with or without structures thereon. Any development authority or any other public body in respect of allottees of buildings or apartments, plots. This shall also include state level cooperative housing finance society and primary cooperative housing society. Any construction business would come within the ambit of promoter, apart from what is written in the exceptions. Now, if we cater to the judgments that have come up arising out of this definition, RERA judgment, Gauri Thate versus Nirmal Developers, it was held in this case that the development manager who sells the property comes under the definition of promoter and is equally liable for the obligations of a promoter. They have further widened the scope of a definition of a promoter, wherein you can bring people like these into the ambit of the definition of promoter, and you can sue them and you can seek reliefs. Any other person who acts as a builder, colonizer, contractor, developer, or any other person holding the power of attorney from the landowner will fall under the category of co-promoter and is obliged to perform all the duties of the promoter was again held in one of the Maharera judgments, very recent judgment again, Niranjan Dashput versus Mr. Rajkumar. The court further went on to speak that whereas if there are more than one person acting as a constructing developer, builder, etc., then all these persons will be held as promoter and will be jointly liable for the duties and obligations of the promoter. So this suffices the question that people put to us that can a landowner be a promoter? The answer is definitely yes. Then the third stakeholder is the real estate agent, which means any person who negotiates or acts on behalf of one person in a transaction of transfer of his plot, apartment, or building, as the case may be, in a real estate project by way of sale with another person, or transfer of plot, apartment, or building, as the case may be, of any other person to him and receives remuneration or fees or any kind of charges for his services, whether as commission or otherwise, and includes a person who introduces through any medium prospective buyers and sellers to each other for negotiation, for sale or purchase of plot, apartment, or building, as the case may be, and includes property dealers, brokers, middlemen, or whatever name caught. Again, very recent case of Maharashtra, Suomoto case number 1 of 2017, where it was held that the respondent, who was a real estate agent, cannot advertise any project for marketing, booking, and selling, or offer for sale or inviting persons for purchase of any building apartment which is not registered under Maharera. Then it is Avinash Ramaswamy, Sanaki, and others versus Ascent Construction Private Limited, January 21, Maharera Appellate Tribunal. It was held that in this case, if the case made by the promoter that DGM Property Solutions Private Limited is a broker in the transaction with the allottees for the sake of argument, then there is absolutely no evidence to show that this company has rendered the services and has actually taken part in the transaction between the promoter and the allottee, as contemplated in the above mentioned definition of real estate agent, to show their status as a broker. On the contrary, if we see what Haryana RERA pronounced in January 2019, in this case of Pushpa Kumari versus Managing Director Supertech, it was observed that the agent has resorted to unfair practices or fraud by creating a forged check with the allottee's fake signature and presenting it to the bank on the name of the allottee. And agent committed a fraud that caused financial damage as well as mental agony to the complainant. Refund was allowed, and the agent was also directed to refund the brokerage amount charged from the complainant along with prescribed rate of interest within 90 days. Then, as we know that RERA has mandated project registration, which has brought a lot of change in the real estate industry that we previously had, where Section 3 to 8 of the Act deals with the provisions of project registration. Section 3 reads as a promoter is obliged to register the real estate project before advertising, marketing, booking, or selling the property or any part of it in any manner. What is the importance? The registration of project is mandatory to provide transparency of work of a promoter so that a home buyer can invest its hard-earned money safely after doing proper research and inquiry. Now, what is the information that has to be furnished by the promoter? The necessary documents relating to the personal details of the promoters like name, photo, PAN card. What we get in terms of project is the size of the project, the current status of the project, if the project is developed in phases, parking area, encumbrances on the land title, if any, third-party rights, if any. These are the things which they need to disclose before taking bookings from allottees. And all this has to be furnished on the websites, making it available to public at large. Details relating to the cost of the project, money collected, money spent, etc. If a promoter is not the owner, then the agreement details, if any, whatever, if there is a joint development agreement between a landowner and a promoter, then we shall also be furnished the details of landowner in that case. Apart from that, a very crucial point that has come up with the registration of projects is declaration stating that 70% of the amount realized for the real estate project from the allottees shall be deposited in a separate bank account to be maintained by the scheduled bank to cover the cost of the project construction. Section 4 2ID says that the separate account has to be self-maintained and it is not an escrow account requiring approval of the authority for withdrawal. There is a statement of accounts audited within 6 months and duly certified and signed by the chartered accountants, where people like you come into picture. And then we also talk about exemption, which are the projects which are exempted from registration in RERA. If the project does not exceed 500 square meters or the number of apartments in the project is less than 8, where the promoter has received the completion certificate for the project prior to the commencement of the act, where the project is only for the purpose of repair or redevelopment, the registration is granted as per section 5 and shall be extended where there is no default on the part of the promoter and the delay is strictly due to force majeure. In the recent past, the promoters were coming up with force majeure, COVID force majeure, and it was held in multiple judgments by the Apex Court that a contractual obligation that you entered into way back cannot be exempted for COVID as force majeure. Because in multiple cases, they were bound to give possession way prior to COVID. Now COVID came and they say it's further a delay. So in terms of registration, if extension was given, that was justified. But in terms of getting the delay possession charges as the delay interest, that was not considered as was held by Apex Court in various decisions. Then, of course, extensions can be granted on reasonable explanation for the projects. There can be a revocation also. As per section 7, the authority may on complaint or suo motu on recommendation by the competent authority revoke the registration granted under section 5 in the following circumstances. If the promoter makes any default in acting as per the act, or if the promoter violates the terms and conditions of the approval given by the competent authority, if the promoter is found involved in any kind of unfair practices, or if the promoter does anything which he's not obliged to do as per the agreement so entered into. So there are so many things which are impliedly there, which are evolving because the law is new. But you will see further in my presentation the judgments that shall come up. But very important principle of natural justice is audi alterum partem, as they say. The maxim means that everybody will be given a chance of hearing. So this section also reads as a notice of 30 days shall be given to the promoter in writing and shall consider the cause shown by the promoter against the revocation during this period. Now, what are the consequences of non-registration? As per section 59 of the Act, a penalty of 10% of the estimated cost of the real estate shall be imposed on the promoter. In case of continued default, an additional fine up to 5% of the estimated cost of the project shall be imposed. If an allottee occupies any property that is not registered under RERA, then it shall have the right to approach RERA for adjudication of such grievances and can sought relief for refund, compensation, etc. However, this approach is not constant. This approach is though followed in Haryana and Uttar Pradesh, but as we see, Maharashtra RERA does not cater to the complaints which are from arising out of unregistered projects. As the project is registrable and has not been registered by the promoter, the authority takes suo motu cognizance for the project to be developed, as was held in this evident case of Rosemary Hospitality versus Anjali Promoters, February 2019, Haryana RERA. Then we talk about contracts that come into picture when we are into a builder-buy relationship. So there's one thing which is known as agreement for sale, which establishes your relationship for a future transaction, and agreement of sale, which establishes a relationship for present transaction. There's a difference between both of these, which is often people ask the difference between agreement for sale and agreement of sale. There is a thing which is noticeable here, which was also held in Durgavati Devi versus Union of India in 2016, that whether it is an agreement for sale or agreement of sale, rights are not immediately transferred and are only affected upon the execution of a sale deed which is again a mandate under RERA also. Under Section 13 of the Act, they deal with agreement for sale, which lays down that a promoter shall not accept a sum of more than 10% of the cost of the property as advance deposit without entering into agreement for sale and shall register the same. Further, Clause 2 of Section 13 includes the particulars that are to be mentioned under the agreement for sale, which includes the construction details, specifications of internal and external works, dates and manner of payment by the allottees, date of possession, interest rates for events of default, and other such particulars. In Maharera complaint number so and so, the complainants had booked a flat in 2016. No agreement was entered into since then. Very interesting case. Respondents were ready to execute an agreement. It was held that refund is given after due date of possession has elapsed, because otherwise the case shall be held as to be premature. In this present case, there is no allotment letter or agreement for sale. Therefore, the provisions of Section 18 of RERA, through which they could have seeked refund, were not applicable. And there is no provision in RERA to grant refund of the booking amount. But since the money has been paid to the respondent, Maharera could only have given the relief under Section 13 of Act. So in such circumstances, Maharera directed the respondent to execute the agreement for sale with the complainants within a period of 2 months from the date of receipt of the order, failing which the money paid by the complainants was to be refunded within a period of next 2 months without any interest. Then, on the other hand, if we see how other RERA authorities are dealing with the subject matter, now the Act has given a model agreement for sale, which acts as a guiding base for the execution of agreement for sale between the promoter and the allottee. And many states like Uttar Pradesh, Tamil Nadu, Maharashtra provide for a model agreement. The parties may stick to the same agreement, but may also choose to differ from the same if consent of both parties has been acquired. And this was held in Prakash Chandra Rohi versus Pivotal Infrastructure. Now, taking it further and correlating with another very landmark judgment of the Supreme Court, Central Inland Water Transport Cooperation and others versus Brojonath Ganguly and others. Now, in this judgment, it was held that terms of a contract cannot be way too arbitrary or unreasonable. Now, if you are deviating from the model agreement for sale, which has come through RERA, and if there is a mutual agreement with the parties, you can do that. But it cannot be arbitrary or unreasonable. You cannot deviate from the law, act, or rules of the respected states while deviating from the model agreement. So, though you can deviate from the model agreement, but it still cannot be arbitrary or unreasonable. In furtherance to this, in another Maharera complaint, there was a delay in delivery of possession as per allotment letter, and no BBA was executed. Thereafter, the respondent builder terminated the allotment, and it was held that unilateral termination by issuing legal notice is not valid in law since the complainant has not accepted the same. Now, execution of agreement for sale, it is a mandate. Non-execution of such agreement amounts to violation of Section 13, Subclause 1, for which a penalty can be charged under Section 61 of the Act. In another case of Maharera, Kamala Bean Jain versus Tapir Construction and others, no agreement has been executed between the parties. Maharera directed the parties to execute an agreement, which holds the relevance of it. Another very interesting case coming from Patna High Court, Anil Kumar Gupta versus Pradeep Kumar Ghosh. So in this case, as per Registration Act, which is a central statute, if we talk, it is not mandate to register the agreement for sale, whereas registration of sale deed is mandatory. But Section 89 of RERA ensures the applicability of RERA over other laws. So agreement for sale in RERA needs to be registered. And before coming of RERA Act in the force, in this case, they had rejected the relief sought by the aggrieved for the reasons including non-registration of agreement for sale. Is this prospective or retrospective? It is prospective. Why? Because the agreement executed before coming of Act in force do not have any bearing on compliance of model agreement. There was no model agreement by then. There was no RERA by then. You cannot expect them to be writing an agreement until there was a model agreement, which is why it is made prospective. And it is for this reason that the Act has prospective effect. And it was held in ICAI Developers Private Limited versus Rajneesh Arora that the definition of agreement for sale does not exclude the agreements entered into between the promoter and the allottee prior to coming of the Act in force, and hence covers both pre-RERA as well as post-RERA agreements. Thus, Section 13 is applied only to prospective agreements between the parties. Now, there is another thing that often comes into picture is about forfeiture of earnest amount. There is no explicit provision in the Act talking about such forfeiture, but there is a landmark judgment which is widely accepted and followed in all the RERA authorities pan-India. It is DLF Limited versus Bhagwati Narula, wherein this petition, there was agreement for forfeiting more than 10% of the sale price would be invalid because 10% of sale price cannot be said to be a reasonable amount which the petitioner company could have forfeited on account of default on the part of complainant, unless it can show that it had only suffered loss to the extent the amount was forfeited by it. Earnest amount is said to be the only amount that is paid at the time of concluding the contract, may it be a booking amount. Thus, amount beyond 10% cannot be forfeited, and if done so, that would be unreasonable. Now, it is a very well settled principle. Now, what are the grounds when the allottees can approach RERA? What are the rights of the allottees? Right to obtain information relating to the project, right to know the completion schedule, including the stage-wise completion and information of the amenities as per agreement for sale, right to claim refund along with the interest and compensation by filing a complaint under RERA in case the builder fails to comply with the agreed agreement for sale, right to have the documents for title, right to claim for rectification of defects by the builders within 5 years of possession if any structural defect occurs in the property. So this is one of the provisions which has widest of its scope, because it says that even after you've taken a possession from the builder, because allottees cannot be asked or expect to know if there is any default in the structure. They are not architects, they are not engineers. So if tomorrow there is a structural defect which comes in their notice, even after taking the possession, their cause of action does not stop there. They will still have the jurisdiction to go to RERA up till 5 years from taking of the possession. Let's see the cases filed by the allottees so far. For delay in delivery of possession, this is the most common reason for which the allottees knock the doors of RERA. So in this case of Haryana RERA, Vikas Chandra Ravi versus Pivotal Infrastructure, the complaint was filed to determine right of complainant to seek compensation for delay in handing over of possession in case where agreements executed between buyers and sellers of real estate prior to coming into force of RERA, whether complainant entitled for compensation. Held all agreements executed between buyers and sellers of real estate prior to coming into force shall be treated valid and enforceable. Provisions of the agreements by which liability of specified amount of money per square feet of super area to be paid by sellers to buyers in event of delay in handing over possession is valid and enforceable. Where extraordinary delay of more than 2 years has occurred without any justification, authority may allow reasonable compensatory interest. Of course, it is defined as per MCLR. In this other case of Asha Mehta versus Edel Landmark, the possession was to be handed over within 54 months plus 6 months grace period, and project is not registered, and respondent is not in a possession of a valid license. Project is not either under construction nor there is of it being taken off. Complainant is not likely to get possession of the flat in the nearer future. Respondent was directed to refund entire amount along with the prescribed rate of interest. Then coming to this Maha RERA appeal, wherein allotment letter did not mention the due date of possession, and the developer was wrongfully communicated about the due date. First, 2018, then 2020, then 2022. Hence, the allotee refused to execute an agreement to accept the delayed possession. Here, the authority held that no grievance when the developer allegedly increased time from time to time. He opined that allotee had in fact accepted 2020 as the date of possession, whereas appellate tribunal revised this order and quashed the order by the authority, said that the documents did not show the date of possession. The developer had originally committed to deliver in 2018, which committed on the RERA portal, and later it unilaterally revised the same to 2022. And it is unilateral extension of the date of possession. Therefore, there is a clear delay in delivering the possession. And this delay entitles allotee to seek refund of his amount with interest under section 8 and 18 of MOFA and RERA respectively. And hence the developer is directed to refund. What happens when there is no due date of possession? In that case, this landmark judgment is followed, that Fortune Infrastructure versus Trevor Del Rima. It was held that although we are aware of the fact that when there was no delivery period stipulated in the agreement, a reasonable time has to be taken into consideration. In the facts and circumstances of this case, a time period of 3 years would have been reasonable for the completion of contract. Now, from then, it is considered that 3 years is a reasonable time for any contract in which there is no time period mentioned. In this case of RERA, the complainants had booked their allotment, executed the agreements, but no due date was mentioned in the agreement. The project was delayed because the government of Maharashtra issued a circular under the Maharashtra Private Forest Acquisition Act, and by mutation entry, the project land was declared as a forest land. Now, Municipal Corporation of Greater Mumbai issued stop work notice, and the project came to a standstill. The dispute was resolved by Honorable Supreme Court in 2014, subsequent to which the entry of the private forest land was deleted from the rights column of the GST. What was held was that lack of mention of due date is a violation of MOFA, and this does not entitle the promoter to take indefinite time to complete the project. The authority also observed that during the period of delay between 2006 and 2014, the respondent could have refunded the allotee the money and compensation, or could have given the allotment, but he instead chose to retain the money. Hence, directed to pay interest. It's a very reasonable judgment according to me. Then, in this case of Satnam Singh versus Ansal Properties and Infrastructure, the complaint has been filed by the complainant seeking refund of the entire amount in a project launched by the opposite parties, number 2 and 1. As possession thereof was not delivered to him by the committed date, it was further stated that by not offering and delivering the possession in question by the stipulated time or even thereafter, the complainant has caused great mental torture and harassment. It has been stated that on account of not offering or delivery of possession of the flat in question, opposite parties number 1 and 2 are duty bound to pay interest to the bank, as the entire amount of loan sanctioned by opposite party number 3 has been forwarded by the bank to opposite parties number 1 and 2. Further, coming to a March 2020 RERA Maharashtra judgment, Sanjay Mahadev Chiplunkar versus Sanjeevani Vyapar LLP, respondents did not have the approval sanctions for constructing and completing the project on the project site. I may go one step further to record my observations that even at the time of registration of the project, the respondents have mentioned that the proposed date of completion of the project was 31st December 2019. Now, even after crossing this proposed date of completion, earmarked by the respondents themselves, they could not complete the project and hand over possession of the flat. Hence, I find that the respondents made false representations referred to the above. What is the relevance of the occupation certificate? In appeal number so-and-so of RERA, according to the allotee, there was a delay in delivery of possession, and RERA authority directed the promoter to pay interest for delay. The aggrieved promoter went in appeal. It was observed that the occupation certificate was attained 5 months prior to the due date of possession, and the promoter requested the allottee to clear the dues and take possession. After promoter could not attain the payments from the allottee, he cancelled their allotment. And allottee alleged that the promoter had not given necessities. It was observed that the issuance of occupation certificate shows that the permission for occupation of building is granted by the competent authority. In such a case, it is rightly so held by the RERA authorities that if a OC is in picture, you cannot contest that there are no necessities because that has been checked. So either you will contest the authority granting OC or you will go to the High Court in the writ jurisdiction and file a writ of mandamus to contest this. Then, in this case of Nandlal Agarwal versus JMD, RERA Haryana, complaint number 5116 of 2019, there was a delay in handing over, and the respondent had charged additional money for increased area, EDC, GST, and illegal demand of VAT. The promoter had also unlawfully advertised the project before receiving the requisite permissions. The respondent contended that he has applied for issuance of an occupation certificate, which was delivered after 2 years. The complainant was entitled to delivery of possession. Due to the delay caused, it was held that if there are any maintenance charges from the date of offer of possession, the same are invalid. With regard to excess monies charged, it was further held that the respondent shall not charge anything from the complainant, which is not a part of the commercial premises buyer's agreement in that particular case. What happens when we do not provide stage-wise completion schedule? RERA Rajasthan had taken suo motu cognizance. The RERA Rajasthan versus Amar Advishwar Infrastructure in 2020 in this present complaint for not providing stage-wise time schedule of the project to the allottees at the time of booking or at the time of the allotment, a penalty of 2 lakh rupees as per the project was imposed on the promoters under Section 61, read with Section 11(3)(b) of the Act. Now, cancellation is a very important aspect again for which people knock the doors of RERA. In terms of cancellation, it is the duty of both the promoter and the allottee to not cancel the allotment wrongfully. Cancellation can only be done as per the terms of the agreement. RERA in appeal number so and so held that the respondent developer demolished the complainant's allottee's allotment and cancelled their allotment on the grounds of stop work notice from the Slum Rehabilitation Authority. However, the allottees alleged that the developer took more allotments from others, hiding the stop work notice, and that termination is wrongful and unilateral. The allotment was cancelled before the RERA came into force. The authority held that it had jurisdiction to deal with such a complaint, and the developer accepts terminating the contract, but contends that due to then pending litigation and unavoidable circumstances, specific performance was beyond his control, hence terminated the contract. Here, the authority rendered the agreement redundant and directed the parties to enter into a new contract if they wish to continue in the project. Aggrieved complainants submitting that the order is ambiguous filed appeals. It can be revealed from the order of the authority neither granted nor refused any of the relief sought by the complainants, and it appears that though the issue of jurisdiction has been answered in the favor of complainants, it takes them nowhere as there is no whisper in the entire order for keeping the reliefs untouched and traveling beyond by issuing directions to the parties to execute agreements under Section 13 of the Act. It was held that remand of the matter is the last resort, and the matter was remanded to the authority from appellate. Further, in RERA appeal number so and so, complaint was filed for delayed delivery of the possession and the authority was directed to pay interest. Aggrieved promoter filed an appeal. Among other reasons, the promoter contended that application of GST as force majeure circumstances which led to the delay. It was observed by the authority that the same will not come within the ambit of force majeure. Suppose that this is a very interesting case which you will appreciate more than I would. Now, in this case, Kapil Tandon versus Hero Realty Private Limited, RERA Punjab. The allotment letter was executed by the complainant, cancelled the allotment under compelling circumstances. When the complainant demanded back his principal amount, the respondent deducted money on account of GST credit, brokerage, and interest. Authority held that can there be imposition of double taxation on the same unit by the promoter, that is, one from the complainant and the other from the prospective buyer. It was held that the forfeiture of 10% of the basic sale price is justified and duly supported following the judgment, and hence deductions such as brokerage, GST, etc. are not lawful and justifiable. As such, the respondent is also liable to pay the interest at the prescribed rate of interest as per the rules of the particular state. Maintenance is another important issue for which people go to RERA. Now, there is nothing which has been defined under the Act in terms of maintenance as such. It is evolving, but there are some duties which are levied on the promoters. It is the duty of the promoter to maintain the essential services and to pay for outgoings till the delivery of allotee is duty bound to pay for maintenance charges after delivery of possession. Once handed over to RWA, the frequency of collecting the maintenance charges is decided by it. On possession, the builder makes the buyer enter into a maintenance agreement clearly specifying the actual amount and the frequency, but later on they can be fixed mutually between the RWA and the builder. In this judgment, as I've cited here, it is clear that the due maintenance of the real estate project can be carried out only if the allottees thereof pay the charges they have agreed to bear, and maintenance of the premises cannot be the responsibility of the developer for all times to come. Pretty logical. Further, in Punjab Haryana High Court, in the case Ragbir Singh Manak versus State of Punjab, it was held that allottees are bound to pay maintenance charges. Then coming to structural defects, it was held in Rajesh Goyal versus Ansal Housing and Construction that if there are any structural defects, it is the liability of the builder to rectify the defects if the defect continue for a period of 5 years from the date of handing over of the possession. And the same was further followed in another judgment of Mr. Naresh Kumar. What happens if the builder is unilaterally extending the timelines? It is in this RERA appeal where the allotment letter did not mention the date of possession, and unilaterally the developer was revising the dates. It was held that it is clear delay in delivery of possession and it entitles the allotee to seek refund as per Section 8 and 18 of MOFA and RERA respectively. What happens if somebody is charging you for the excess super area? Was very well dealt with this complaint in Haryana RERA Gurugram, where the complainant was being charged with increased super area than what was mentioned in the agreement. It was assumed that the plans were approved, but it was revealed later that the approval of plans was attained at a later date. It was held that the agreement made between the parties in regard to these facilities is rather vague. The respondent should have precisely defined the area to be calculated under such facilities and also the rates chargeable for the same. Since costing of these facilities has not been defined properly and unambiguously, they now have to be interpreted in a reasonable manner. Then what happens when VAT charges are imposed? It was held by RERA Panchkula that VAT charges have been quantified and demanded by the company through final account statement, and so they are justified. Now, some people say that RERA is only allotee centric. That's not true. It is also balancing the interest of the stakeholders, both promoter and allotee. What are the grounds for the promoter to approach RERA? Right to cancel the delivery of possession in case of default of payment by the buyer. You cannot wait indefinitely for the allotee to pay. You have the right to cancel the unit, which should not just be a unilateral cancellation. What would not amount to a unilateral cancellation is that you're cancelling the unit as per the terms so enumerated for sale or the builder buyer agreement. If there is a genuine delay in the registration of the project and the promoter is not at default, then the promoter has a right to approach RERA authority with an application to get extension for the same. In case these rights of promoters are violated, he can approach the authority. Apart from that, there are a number of duties that are imposed on promoters to fulfill and avoid unnecessary proceedings against him. Duties mentioned under Chapter 3 of the Act are as follows. Duty to provide correct information on the websites and in the advertisement, a violation of which would be a veracity of advertisement under Section 12. In this case of RERA Maharashtra, Amit Surana versus Yog Siddhi developer, MahaRERA feels that being promoter of the project, the respondent is bound to follow the provisions of RERA and to update all required information on MahaRERA website to keep transparency required under the RERA. Further, they are duty bound to not take more than 10% of the advance deposit from the allotee. Then, duty to adhere to the plans of the project as mentioned under Section 14. The promoter, even after conveyance of this project, shall have the responsibility towards the allotee for rectification with subject to structural defects, as was held in the case Rajesh Goyal. Duty not to transfer the rights and obligations to any third party. Duty to obtain all the required insurances. Duty not to transfer the title deed to any other person. Duty to abide by the terms of the agreement for sale. When does a promoter file a case in RERA? A promoter can file a complaint against the allotee if the allotee delays in making timely payments. A promoter can file a complaint against the real estate agent if this agent misrepresents anything related to the transaction or information relating to the project. A promoter can approach RERA if there is any unlawful hindrance being created by the allottees, development authority, or any other person in completion of the project. A promoter can file a complaint against allotee if they violate the orders given by the authority. A promoter can file a complaint against the allotee if allotee delays to occupy the property after getting the documents for the same. And in this Neel Kamal judgment, 2017 only, it was held that RERA law is not to be considered as anti-promoter. The authority can impose penalty or interest not only on the promoter but the allotee as well, on account of contravention of obligation cast upon them. The legislation is unbiased and is a law for regulation and development of the real estate sector, rightly said so. And hence a promoter can also file a complaint against the allotee, but only as long as there has been a violation of the act of the respective state rules of RERA. In this case of Ashrita Singh and others versus Landmark Apartments, it was held that holding and maintenance charges can be charged only the date of actual handing over of possession or the date on which allotee was obligated to take possession. Even if the allotee has not taken possession, your charges will begin from that very date, but not prior to that, was held in this very case. Further, in the case of Puri Sons Engineers versus Subset Properties, the allotee was directed to take the possession of the subject flat within a period of 1 month from the date of issuance of this order, failing which he shall be liable to pay holding charges. The allotee was directed to pay outstanding dues, if any, after adjustment of interest awarded for the delay period. In the Supreme Court judgment of Irio Grace versus Abhishek Khanna, which came in January 2021, it was held that where phase 1 of the project had been issued occupation certificate, the developer offered the possession to respective allottees. Supreme Court directed the allottees to take the possession of the respective allotments. Similarly, in a case of UP RERA, the promoter had offered possession and has also had occupation certificate on record and requested the allottees to take possession of his allotment, which was being delayed by the allotee. The UP RERA directed the allotee to take possession of the unit within 45 days after paying the pending dues against the same. In Puri Construction versus Sanjay Goyal RERA Haryana, where the allotee had defaulted in making timely payments and taking possession even after the offer of possession and occupation certificate, it was observed that since the respondent has defaulted in making payments of outstanding dues and taking possession of the apartment in question, so there is a violation of terms and conditions of the agreement and also violation of obligation of allotee under Section 19, subclause 6 of the Act on the part of respondent. Hence, the complainant entitled for delay possession charges at the prescribed rate of interest of 10.45%, which was then prevalent. In this evident case of Maharashtra RERA, the builder complainant completed the project, got OC, but the respondent allottee failed to pay. Taking consideration Maharera, it was held that the builder can cancel the allotment and it will not be held as a unilateral cancellation. Similarly, in another complaint of Haryana RERA Gurugram, occupation certificate was received on so and so date, possession was offered on so and so date. However, the respondent allottee failed in taking possession, thereby violating 1910 of the said Act. Further, the complainant shall be liable to pay delayed interest charges at equitable interest rate of 10.45%, which was then prevalent from the due date of handing over of possession till offer of possession. When can a real estate agent approach RERA? As per Section 10 of the Act, the real estate agent is under obligation to not to facilitate any kind of sale or purchase of any property that is not registered under RERA, to maintain records or books of accounts as per the provisions of the Act, not to indulge in any unfair trade or practices, help the allottee to get the necessary information and legal documents relating to the property, any other such functions. In case the real estate agent is unable to fulfill these obligations, then other party may approach RERA to file a complaint against the agent, and if this agent in any way feels aggrieved, even after fulfilling its part of duties properly, then he has the right to approach RERA for relief. What are the cases which are filed by the real estate agent? In this case, order was passed against the real estate agent. Hence, the real estate agent went in appeal in Bennett Property Holdings Company Limited versus Vellamal and others. The appellant, who was a marketing agent, filed appeal against the order of the authority in violation of Section 12 of the Act. It was held that as he was a party to transaction, and the promoter, so he is liable for this to get back the amount from the promoter as per MOU. Further, a very interesting portion which has now been dealt with very well. Landowners, they are not defined in the Act per se, but they are the fourth stakeholders. A landowner is the person having a piece of land and right to get revenues out of this land. A landowner has complete right over the land to sell, mortgage, or construct a building over this land. A landowner has a land but does not have proper requisites to perform construction on this land. So he may adopt help from a builder developer for the same and construct a building. This is joint development agreement contractual relationships. How do they come within the ambit of RERA? What are the agreements between a landowner and the builder? Sometimes they mutually divide shares amongst themselves, that there's an arrangement that the landowner gives the full responsibility to the developer for obtaining all the approvals, launching, marketing, construction, etc. On the other hand, landowners just have the land, and in return, the landowner will get the consideration in form of lump sum money from the developer or percentage of sales revenue. But usually these JDAs, they do not allow the developer to sell the land. But it is not a blanket formula. It depends from person to person, and it is permissible. People also do a GPA. In this agreement, the landowner confers the authority to the builder developer to develop its land and sell the land on behalf of the landowner. In this, the landowner may get 30 to 40% share of the total outcome. Now, coming to the authority, we know that there is authority. There is adjudicating officer. Then they have the powers of execution also with the authority. There is appellate tribunal also, and all this together formulates as RERA. Now, the authority, Real Estate Regulatory Authority, is a body that helps to fulfill the aim of RERA efficiently and effectively. This authority mandates the promoter to disclose all material information and also to register their project under this authority and to provide transparency and accountability of real estate work. Just excuse me. Sorry. Yeah. So we were talking about the functions and the concept of the authority. The functions are enumerated in Section 34 of the Act, and it provides the functions of RERA authority as follows: right to register and regulate the real estate projects and real estate agents, right to publish the information relating to projects for the public on the RERA websites, right to collect information and maintain database of promoters and agents. RERA authority needs to fix the rules and regulations for each area under its jurisdiction. The authority ensures the compliance of obligations of the promoters, allottees, and agents. It ensures the compliance of orders duly passed by it. What are the powers that the RERA authority has? They have power to call for information, conduct investigations as per Section 35, power to issue interim orders as per Section 36, power to issue directions as per Section 37, power to impose penalty and interest and take suo motu actions if required as per Section 38, power to rectify defects, if any, under the provisions of the Act as per Section 39. How about the adjudicating officer on the other hand? AO shall decide the matters for compensation under Chapter 3 or interest claims within 60 days from the receipt of such application in compliance with Section 71 of the Act, but cancellation of allotment is under the jurisdiction of authority exclusively, which was so held in Sandeep Maan and others versus RERA Authority Punjab. Now, what are the powers of the adjudicating officer? How do we differentiate the powers so conferred with the authority and the adjudicating officer? AO has the power to summon and enforce the attendance of a person as witnesses, power to conduct inquiry, power to grant compensation against builders, promoters, if there is a violation of Section 12, 14, 18, and 19. And there are other provisions also so enumerated under Chapter 3 of the Act. Now, AO has to consider the following things before awarding compensation. Number one, the amount of disappropriate gain or unfair advantage wherever quantifiable made as a result of the default, the amount of loss caused as a result of the default, the repetitive nature of the default, such factors which the adjudicating officer considers necessary to the case in furtherance of justice. Further, what are the powers of the appellate tribunal? To summon and enforce the attendance of any person. Appellate tribunal has powers just as the civil court to receive the evidence on affidavits, issuing commissions or examination of witnesses and documents, dismissing an application for default or directing it ex parte, reviewing its decisions and any other matter as may be required, power to regulate its own decision. And on what grounds can we be going under appeal in RERA? Any aggrieved party who is not satisfied with the decision of RERA authority has the right to file an appeal against the order of the authority for granting relief and justice. But there is this 60 days period that the appellate tribunal shall not take more than 60 days for the adjudication of matter from the date of filing of such appeal. If the tribunal is unable to sought relief within the time limit, then they shall record the reasons in writing for the same. Now, there are subvention schemes which are also being sold pan India, and there are issues as regards pre-MI that come up, for which I have brought out these two evident cases, Madhukar Gupta versus Supertech. It was held that the pre-MI will be deposited by the promoter until the delivery of possession to the allottee, and there can be a separate agreement for this subvention scheme or a provision included in the agreement for sale itself, and it shall be so valid. and the banking institution can also be a part of it. Similarly, in Avinash Agarwal and others versus Royal Living Homes Private Limited, Rajasthan RERA, case number so and so, it is the duty of the respondent to fulfill its obligation casted upon him by the virtue of memorandum of understanding dated so and so. The respondent is that PMI regularly till offer of possession. This is again so held in another case of Abhishek Singhal versus Supertech in Haryana RERA. And this brings my presentation to an end. So whatever queries, if any, can be called upon from the participants. And here is my email ID and mobile number for any queries. If anybody wants to drop in a message or email tomorrow regarding any queries in the subject matter, I am always welcoming.
Thank you so much, Harshit sir. I'm sure this was a power-packed information that you have given, and thank you for giving the insights. There are few queries. Let me just share my screen. Right. Just let me know whether you can see it, because there are 10 queries.
Right.
So can you see?
I can.
Yeah. Okay. So the first query is. In RERA registered project, a flat is purchased in 2015 and till the date the possession is not done. In fact, the flat which is purchased for which the sale agreement is registered is not yet constructed. What is the course of action against the builder?
Yeah, so you can go for refund if the construction is not there. The project you are saying is registered, and you had purchased it back in 2015, if it is still not constructed, you can go for refund with RERA.
Okay.
Under Section 18 of that. Yeah.
Okay. The next query is effect of CS certification of RERA account if change in FSI on the revised drawing.
Sorry? Yeah.
So the second question is from Praveen. Effect of CS certification of RERA account if change in FSI on the revised drawing.
I would want him to elaborate this question as to what he's wanting to know exactly.
Okay. So Praveen, if you're listening, please elaborate the question so that Sir can answer it in a right way. The next one is from Atul. Whether
meanwhile, we can cater. Yeah. Whether the land developers are covered under the RERA Act, yes, they are. And I have put forth the precedents for the same also. Okay. Because they will fall within the definition of a promoter. Landowner is equally a promoter. And calculate land cost when landowner is given cash consideration plus certain area.
Mm-hmm.
Yeah, so this is something that the RERA authority will do. If you're talking about the land cost estimation, so there are two things. There is a builder-buyer relationship and then there is a RERA-builder relationship. So calculating the land cost is something that RERA does for the builder. Buyer has to limit their rights with respect to their contractual relationships that have been entered into. Now, a land cost is calculated at the time of registration, and if a penalty has to be imposed, has to be done by RERA. So this land cost will be computed by RERA, and they shall take into consideration all the factors. You need to know the total land cost. You can know it from the RERA.
Okay.
Now, whether builder is allowed to withdraw amount for construction expenses from 70% without submitting CA certificate to the bank, no, they cannot. Whether OC is received for a particular project and project is completed, the actual project cost may be lesser or higher than estimated project cost. If actual project cost is 88% of estimated cost, do a CA engineer revise estimated cost? Yes, they need to revise the estimated cost in the certificate that they issue. If a developer registered under the Act, can it be registered under
registered
Society
under
Act? Society Act without OC? No. They still would want OC.
Okay.
Then I had filed a complaint in RERA. What does this mean? UP.
UP.
For delay in possession. Yeah, must be UP. An online court held wherein judge allowed time to builder to apply with affidavit. After that, it is shown in side case disposed of. No meeting last 6 months. What remedy do I have? Where to appeal? You can go to the appellate tribunal, but there must be some order which would be coming on the official website of RERA. So first you need to download the order as to what order has been passed. Was it a dismissal in default due to some procedural deficit, or has there been an order passed in favor of any of the parties? So first check that, and post that you can file an appeal. You can drop a text to me. I will try to help you out with this also. Then in case of redevelopment, developer had shown the final plan to tenants. Okay, neither have executed any registered agreement for redevelopment or mentioning what would be rewarded later for his old property. This does not fall within the jurisdiction of RERA. This is not a case which will fall to RERA.
Okay.
Yeah, next.
If builder
gives to individual apartment owners but do not complete the common facilities as proposed, what is the relief sought? So you can go under section 12, veracity of advertisement. You can say that it was proposed that there is going to be a club, a gym, a park, etc. For that, you need to substantiate. You will click the recent pictures of the project and you will show the brochure or prospectus of the project, which was then shown to you, or their website images or something. So either from the website or, I guess, prospectus or brochure, if they're committing anything regarding the common facilities which they do at the inception of the relationship, that can be compared to what they are giving to you on site right now. And you can see compensation from the adjudicating officer in this regard.
Okay, so these are the queries, sir. Let me just check once again whether we have any more queries. Just a minute. Yeah, there is one more query. Okay. So let me just share the slide. Yeah. So can you see? So this is a query. If agreement to sell was executed before RERA became applicable and project is still incomplete, whether allotee can approach RERA for grievance redressal, can a ground that terms of agreement are more favorable to builder can be taken in respect of agreement executed in pre-RERA period.
So it depends that which state are you talking about. If you talk about Haryana, Uttar Pradesh, etc., you can do that. For RERA, you have to see that it is registered first and then you can file a complaint. This does not matter when was the agreement entered into. What is the current position will have to be seen, and then further, of course, you have got your rights and you can get it enforced.
Okay.
Yeah.
So the next query is from Lalit. If the builder has not been able to fulfill his promise of getting the road on municipal land, resulting in poor connectivity to the project and no market value, can the investor go to RERA?
Yes. Investor can go to RERA. RERA will direct the builder that it was you who had to facilitate it from the government and get a road constructed, and they will direct the builder to do the same. And there has been such a judgment already passed by RERA. So this can very well happen. Yeah.
One more question is from Bhushan. My question regarding land cost was with respect to certificate by CA in Form 3. How to calculate land cost? The one which you answered previously, sir. That is regarding that.
Okay, no, so I will not be in a position to answer this question because
Okay.
this is in respect of chartered accountants only.
Okay.
Yeah.
So the next question is, what if a lottee is unable to pay further amount, which is 90%, then will he get his 10% amount back?
But if a lottery is unable to pay further amount, which is 90%. So yes, of course, for booking amount, if you are saying, if you've just paid booking amount and you seek a refund of that, it will depend on what grounds you are seeking the refund. If the project has not taken off and it cannot be anticipated as to when the project would be handed over. So ground shall depend, but yes, you can. There is no explicit provision, but you can.
Okay. And the last question we have is RERA applicable to lease for 30 years?
It is not.
Okay. I guess since we are done with the questions, no more questions, I guess. Just check. Yeah. Okay. So we are done with the questions. Let me just stop this sharing. Yeah. So thank you so much for coming here and taking your time out from your working day and guiding us in respect to RERA, which is a crucial topic, I must say. So on behalf of Pune branch of ICAI, I would like to thank you for giving us insights, and definitely we would like to see you again on some another topic or another subject, definitely. So thank you so much, sir.
Sure. It's my pleasure anytime and always welcome. Thank you.
Definitely, sir. Thank you so much, sir.
Thank you. Thank you.